This one, I know you know the answer to, Chris. What is a residuary clause in a will?
Disposes of everything that hasn't been otherwise disposed of in the will. So you've got your specific bequests where you say, I want my sister to have my purse and I want my mom to have my dog. And then you have the more general bequests of, I want my kids to take my money or my accounts or my house. And then you have the residuary that says everything else goes to whoever. Usually it's the kids or the heirs at law.
Welcome to episode 96 of the Weekly Docket, a podcast by the Silberman Law Firm, where we talk legal news and practical law. Today is November 12th, 2025. I'm Phil Silberman, owner of the firm and your host. I'm joined by Christopher B. Heald, who is our firm's supervising attorney at the firm. How are you
Hanging
doing
in
today,
there.
Mr. Heald? Good. I understand that we were talking a little bit before the show, and I thought you had a trial setting, and you said, I hope not. I'm on a trial docket. Explain to the listeners how that works. When your case is set for trial, versus you just have this period of when you might try a case.
Well,
Explain
sometimes
how
you
that
might,
works.
and what people want is you might have a trial set for a certain day, and they say, okay, we're going to call you on November 12th, and it's going to be a 3-day trial months in advance. That's really nice. Usually, it's not that easy, though. They give you a 2-week docket starting on a Monday, and they say you could be called to trial anytime during these 2 weeks. So as of that Monday and through the ending Friday, you, your client, your witnesses, everybody, be ready. We might call you, and if we call you, we'll give you a day's notice if you're lucky, maybe 2, and show up and try the case. So I understand the reason for the system. Cases settle. Courts have to shuffle their dockets around. So no shade at the courts, but it makes for a little bit of high anxiety when you're waiting and your client's calling you every day saying, are we going? Are we going? Are we going? But that's what it is. So currently I get to wait and see if we have a case called to trial this week or next week.
And that's a product of the fact that courts want to try to be efficient, and they'll have a case that they think's going to go, and then it gets settled. So then they want to try to get somebody
and a lot of
else in.
times
Is
they'll
that
have
what's
the
going
first
on?
3 or 4 lined up. Or if they know it's going to be a full week, they'll block out a full week and say, okay, you're going to go this week. Most of our trials are not that long. I would say the great majority of trials we do are 2 to 3 days, which I think is the majority of trials. And so they try to just fit those in between cases settling and between cases starting and then having to stop and start up again. They try to wedge those short trials in there.
Yeah. All right. That's a little bit of a bonus question today, since we happen to be talking about that. But on our docket today, we've got some legal questions, and then we have a little rant and rave. Legal questions. Number 1, what do I do if I'm owed rent and it's over $20,000 and I need to evict? Okay, that's question number 1. Question number 2, what is a residuary clause in a will? I'm adding in a will. Tips about a residuary clause. And then 2 related questions. Should I answer a lawsuit if I've not been served? And then if you're on the other side, let's say I can't get somebody served, should I file a motion for substituted service, and when should I use it? And then in our rant and rave section, not so much of a rant or even a rave maybe, but we've been doing some recruiting and trying to figure out, why do so many really good qualified attorneys want contract work right now? We'll talk about that. So let's go ahead and get it kicked off with our legal question section. And first question we've got is, what do I do if I'm owed rent over $20,000 and I need to evict? Chris, the real question here is, okay, I know that I have to evict to get possession in a JP court because JP courts have original jurisdiction. But gosh, I also checked the jurisdictional limits of the court, which says it's $20,000, and I'm owed $23,000 of rent. Can I just plead down to the 20 and get the 20 grand and the judgment for possession? Do you have any
of course
thoughts
you can.
on that, Chris?
No, you can't. I'm
Okay.
kidding. People do ask us that a lot. They say, hey, can I just get what I can get? And it would be easier. I definitely understand why people want to do it. But if you are owed rent in excess of the jurisdictional limits of the JP court, you can seek your possession in the JP court. and then you can go file a suit in county court for the rent that you're owed.
Yeah, that's the right answer. This came up in our chat Google space among all of our lawyers, and I'm afraid to say that they got the wrong answer. One of our more senior attorneys was speculating that, yeah, just go ahead and plead it down. The idea is you can't really circumvent jurisdiction, right? So you can't say, just if you were in a county court, what's a county court? I don't even know what a county court's jurisdiction is now. It used to be 200 grand, whatever it is, but you can't just plead down to stay in the court. Now, if the judge doesn't know any better and no one's asking, will it ever be caught? I guess it's possible you could go in and be like, hey, I've got 19 grand of back rent when you really have 24. That may be making a type of misrepresentation to a tribunal, so I don't recommend that if you're an attorney. But I think the JP court judges will get this right, and they'll say, no, I can hear the eviction, but if you want that back rent, Mr. Landlord, you need to go file a separate breach of contract lawsuit in a county court or a district court if you want. That's the idea. Chris, I always wondered what were to happen if you were just to proceed in the JP court, having pleaded down your damages, and the court actually didn't have jurisdiction, and then you were to go and get the judgment, and then an enterprising sort of attorney were to file an appeal and say, and it was way after the appellate deadline, but you'd say, your judgment is absolutely no good because the court never even had jurisdiction to render the judgment.
It's
What do you think about
creative.
that argument, Chris?
I don't think we ask that question when we do intake, but asking, hey, is it possible you owed more than what they said you owed, such that we could deprive the court of subject matter jurisdiction and have their order set aside? I wouldn't hang my hat on it. If your client has a $19,000 judgment and you're looking to get creative, it might be worth a shot.
Yeah. The things I think about. Okay. Let's go ahead and move on to our next legal question. This one, I know you know the answer to, Chris. What is a residuary clause in a will? You know it. What is a residuary
That's a clause that disposes of everything that hasn't been otherwise disposed of in the will. So you've got your specific bequests where you say, I want my sister to have my purse and I want my mom to have my dog. And then you have the more general bequests of, I want my kids to take my money or my accounts or my house. And then you have the residuary that says everything else goes to whoever. Usually it's to kids or to heirs at law. But just in case I missed anything above, everything else goes to XYZ.
Yeah, and it's counterintuitive because I always think about the residuary clause being, you think about the residual, right? Sometimes residuals aren't very good. Like if there's only like a tiny piece of cake left, right? And someone says, hey, there's no one ever uses these terms, but yeah, we ate 99.9% of the cake. All I have is this small residual left. And you think, that's really crummy, pun very much intended. And dad pun, I know. But in the land of estate planning, the residuary clause is actually the good stuff. It's because most wills are simple. They don't do a lot of specific bequests. And the residuary clause is just who gets everything is normally how it is. What do you think about, do you typically see people leave it to the heirs at law? Or do you see typically people leave it to a specific
like I was saying,
person?
usually it's one or two specific bequests. Some people have 10. I tell people you can have as many as you want. Doesn't matter. Your china, your gun, whatever you want to give to whoever you can. And then typically they want to give things to their kids if they have kids. And so a lot of times they've disposed of everything at that point anyway. They say, and the rest or they say anything remaining. And then after that, then they go into the specific residual language. So I don't want to say you have two residuary clauses, but a lot of times it'll be, here's the specifics. After all that, everything to my kids. And then should my kids free to cease me or a long line of people, there's just no one you can find, then go here because they really don't want to create an intestacy. So it's typically kids, then heirs.
Let's say hypothetically someone just did the will and left it to the heirs at law. Would they then have to do a determination of heirship in the middle of the testate probate, which seems to be weird.
Some judges might make you do it. I think others would not. I think it's going to be up to the judge to say, it says heirs, I got to do an heirship. And I think others would say they've identified who their kids are, We know who the kids of their kids are. So as long as we can elicit testimony as to who those people are, there's no issue. My hot take, I hate to give opinions, but you want my hot take on this hot button issue, I would think that's a little outside the court's jurisdiction. If it says to these people, it's incumbent on the executor to do that job and not the court, because the executor is responsible for following the will. It's not, in an independent administration, it's not the court's responsibility to then step in and make sure he knows who the heirs are. But I think some courts have been known to do things like that.
Okay. All right. Very good. Next question we've got to talk about is, should I answer a lawsuit and I haven't been served? I get that all the time where people call it, okay, I've been sued, and they know the processor is out there, the process server is out there chasing them around, and they don't really want to spend the money right now to hire an attorney. We're getting near the holidays. They need some extra money. I say, hey, can I just run from the process server for a while and wait to answer until I get served? What do you think?
You can. Chris? I don't like it, but a lot of people get away with it for a long time. So who am I to tell you what to do? If you want to live dangerously and play that game, you can. I always worry that they're going to be able to prove that you were served, even though you say you weren't, or they're going to get substituted service on you, and they're going to tack it to your door, and then you're going to forget to tell the lawyer, or you're going to go on vacation for a while, and you're not going to see the service, and they're going to find a way to get a default against you. So I don't like living that dangerously, but on the flip side, we know people that dodge service forever and cause us a lot of frustration, and having to track them down or get motions to substitute service on them. So we get to see both sides.
Well, we've got one right now where they're about to get DWOPed and trying to get somebody served, and the process server thought he was dead. It turns out that he wasn't dead. And then where is he? And he always got a new address, and then amend the petition, get that to the process server, and get it done.
I don't want to rant, and I may have said this on this podcast before, but I always thought process servers hid in bushes or dressed up as pizza guys and walked around with a pizza and served you. Apparently, that's just not what they do. They knock on the door and they say, hi, do you want to be served with this lawsuit? And to foil them, all you have to do is not answer your door. It's like the greatest legal loophole there is. Just don't answer your door and you can't be sued. It's a little frustrating.
The real good ones do hide and disguise themselves as like pizza servers, and are also double as great disguise artists. To me, the big risk is the getting a motion for substitute service and you don't know that you've been served, and then the other side goes and takes a default judgment. That's the real risk. And if you are on the other side of this, and let's say we're a plaintiff, what do we do when they're dodging service? We will eventually say, hey, judge, we've tried to serve them so many times, and we have good evidence they actually do reside at this address, and we'll file a motion for substitute service and ask the judge to allow us to probably just leave a copy of it at the door. So that way, eventually when I'm not answering, here comes that process server again, I'm not answering the door. And then the process server just leaves it. He didn't personally serve me. Now I've got him. And the person getting served doesn't realize there was a motion granted to allow that type of service. So, yeah. All right. And then moving on to my favorite part of the show, rant and rave section. Is, I don't know if this is a rant or a rave or what is it. Why do so many qualified attorneys want contract work right now? We tend to always be recruiting lawyers, it seems. And I have some job postings out there. One's for just our standard W-2 position, and another one's for a contract lawyer that maybe is going to work less hours. And I was shocked to see just the number of really qualified people wanting contract work. Any guesses why that may be, Chris?
Maybe it's a little more, it doesn't feel as oppressive. People want to work. Obviously, we're lawyers. We all went to school, but maybe they want the constraint of having to bill 2,000 hours a year. And they say, look, I'll happily work as much as I can, but they don't want the structure. I don't know. That's my guess.
So it's like dating. For people who don't want to get married to the practice of law, it's, hey, I don't necessarily want to get hitched to this thing, but if it's dating and we're just boyfriend, girlfriend, then it's much less stressful.
Describing 80% of the date, so you may be onto something.
Okay. Could be a product of the economy. A lot of solos, a lot of people at law firms don't have enough work. Maybe the economy is turning on us and they're keeping the firm employer is still paying the salary, hanging on to the associate, and the associates say, hey, I'm not getting enough work, so they've got some extra bandwidth. I'm shocked, Chris, unless they're lying to us, I'm shocked that a lot of the law firms allow them to work contract if they're paying them W-2 full-time salary. What do you
I-
think about that?
Like you said, it's a part of the economy. It just, if that's the way it is, it's the way it is.
The only thing I can think of is maybe if you're a firm management or a firm owner and you've got good associates and you don't have enough work for them, and oftentimes there's a productivity bonus component for higher compensation. You think, well, I can keep the associate, and if I let them go out and do some contract work, and that way when I pick back up, I'll still have the associate. So maybe that's what's going. A lot of solos also, I think the solos I interview for this type of position, the contract position, I think they're always hopeful that their practice is going to pick back up. So if you own your own firm and you're a solo and you don't necessarily want to go work W-2 full time for another firm, I get some contract work. And then when my practice picks back up, then I can wean off my contract work. So that could be what's going on. And then I think the last plausible argument, which I think is the least becoming to our Gen Z attorneys, our young people, is young people may just not want to work that much. They don't want to work full time. They want to travel. They want to have fondue parties and charcuterie board parties or whatever they're doing and play Dungeons and Dragons. And then they just only work 20 hours a week. What do you think about that?
I don't know that that's it, but it might.
Chris is always so reserved to talk about Gen Z.
Wait till they start talking about where.
They're already
I
talking about us.
I like to keep it all calm.
Yeah. All right. Look, I'm happy to. There's a lot of interest for contract work. That's great. I will. Final point: if you are a law firm out there, we do have a lot of lawyers that listen to the show. And Chris, it turns out that a lot of lawyers are listening to the show and then hiring us because I'm getting lawyers that have disputes and issues with their law firms and they're coming to me for advice, which I'm happy to help them with. I just thought that was an interesting product, of the show. But here's a final tip. All right. If you're thinking about doing contract work out there, or you're a firm that's thinking about hiring some contract attorneys, remember conflicts checks can be a bit of a pain because now you have to run conflicts checks against multiple firms. So if you already work for a high volume practice that has a similar practice to a firm you're going to go do contract work for, that's going to be maybe not a great fit because you may run into a lot of conflicts. So just be careful, be wary of conflicts checks when you're doing contract work. That's my final piece of advice. Chris, agree or disagree with that last one? Yep. Okay. Thank you. All right. That brings our show to a close. I've been your host, Phil Silverman. Chris Hill has been my co-host today. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show is to be considered legal advice. And this is all done for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com. That's info@silblawfirm.com. Tell us you want it publicly answered in the podcast. Everybody have a great rest of your week.